welcome to Crime in Court. My name is Heather, and this is episode 8, the Denny motion of Wisconsin versus Zachariah Anderson. And I just wanted to put the thumbnail back on the screen because to your left, you will see Michael Campbell on the stand for the trial, the 2023 trial of Zachariah Anderson. That was the individual on the stand is Michael Campbell, who we will be talking about in this episode. The other two pictured are Zachariah and Nicole. He's whispering something to his defense attorney in that picture. So back to the Denny motion. So what is the Denny motion? This is a really great resource that I found from the law offices of Christopher J. Chirella, and he is a Wisconsin attorney. And basically, he breaks it down very easily for us to all understand what Denny is. Denny's is the defendant's need to get court permission to blame someone else. So you can't just go into trial and say that person did it. It was him. You have to actually have court permission from the judge to bring another person in. So this explanation: courtroom dramas often depict a mid-trial surprise. The finger of blame is pointed to another person's direction. Like I just said, the person could have committed the crime, not the defendant. These scenes make a great plot twist, but it's not what happens in Wisconsin courtrooms, because Wisconsin is a rare state where the criminal defense attorney must first get permission from the judge in order to introduce any other possible suspect in the case. So they seek that permission through a Denny motion. They have to file this Denny in order to and prove why. They have to prove enough evidence to the court to bring in this third party. So an example of a Denny motion occurred in Green Bay in October 2020. Jason Mendez Ramos's life was ended in September of 2021. The defense attorney for one of the suspects, Pedro Santiago Marquez, was denied the right to blame the crime on a witness that the state plans to call to the stand. If he does testify, the defense will be able to cross-examine him about his involvement. All right, so the history of the Denny motion. This unique motion stems from the 1984 case State versus Denny, which I actually found the Supreme Court ruling on that, and I might do like a little side episode just to read through that Denny motion because it might be a little interesting. But anyways, hold on one second and let me take a sip. As soon as I get talking, my mouth starts getting dry. I'm on medications too that makes that happen, so that doesn't help. Anyway, so in 1982, Christopher Moore, his body was found stabbed to the point where he was no longer alive, and brothers Kent and Jeffrey Denny reportedly bragged about the crime to their friends and family. They were ultimately charged with the crime and tried jointly. They were both convicted in 1982. In his appeal, Kent Denny made 3 arguments. 1, he and his brother should have been tried separately. 2, he was denied his constitutional right to present a defense when the trial court refused to allow evidence suggesting that third parties had motive and opportunity to commit the crime. Denny contended that the trial court was not wrong to prohibit his defense counsel from reviewing police investigation reports that supported the theory that others could be guilty. So the trial court was wrong to deny him the right to look through other reports, investigations, things like that, and to put those forth as evidence that somebody else could have done it. So, his appeal was denied. Among the points made at the appellate level is that motive alone was not enough to cast suspicion on another person. The defense would have to satisfy the legitimate tendency test. So, this is what you need. For a third party to be introduced as a possible guilty party, the defense must satisfy 3 requirements. 1, show that the person has motive to commit the crime. 2, show that the person has the opportunity to commit the crime. And 3, present evidence that connects the person to the crime. The court ruling stated that the rule would place, quote, reasonable limits on the trial of collateral issues and avoid undue prejudice to the people from unsupported jury speculation as to the guilt of other suspects, end quote. So you can't just be throwing around blaming everybody else. You don't want to prejudice the jury by doing this. And yeah. All right. So that's just how it is in Wisconsin. I don't know if it is that way in Illinois, but I don't think we have Denny. I'm not sure. In the defense case, the appeals court said that Denny's offer of proof was deficient. One proposed witness was going to testify that 2 other named individuals had a possible motive to kill Moore, but did not offer opportunity to or evidence that linked them to the crime. Okay, so you need to provide enough evidence to link them to the crime. And another proposed witness was to testify that a third person was angry at Moore, but once again did not offer evidence related to opportunity or connection to the crime. So you have to have all 3 elements. Without all 3 elements of the legitimate tendency test, any Denny motion will fail. So, defense, it seems like a high burden, but I don't know why it's so difficult to introduce somebody else, but that's the rules in Wisconsin. So prosecutors are not obligated to convince a jury of a defendant's motives, yet the defense must prove motive when presenting a possible alternate suspect. So again, the prosecutors, the person trying the case, the ones who have the burden, they don't have to prove motive. But if you are trying to get Denny evidence in, you as a defendant, to defend yourself, you have to prove motive. So that's just kind of the double standard that exists with this. But anyways, so the defendant also must show the other suspect had a direct connection with the crime. Prosecutors can bring someone on trial on circumstantial evidence alone. These guardrails can sometimes lead to wrongful convictions and allow true culprits to remain free. In a high-profile and controversial case, the Denny rule was partly responsible for keeping Stephen Avery behind bars, interesting, for a crime he did not commit. So that explains a lot, that they couldn't provide evidence that pointed to other guilty parties when there was clear evidence. All right, so 10 years after he was convicted of the R and attempted M, I'll just say, in 1985, DNA advances showed that the DNA from underneath the victim's fingernails was not Avery's or hers. Avery also provided evidence that law enforcement investigated another suspect but failed to tell his defense lawyers. So twice he got shafted by this Denny garbage. Where was I? All right, so despite this new evidence and more than a dozen alibi witnesses, the appeal court denied him a new trial. Avery was freed only after, that's what I was looking for. So this was his first conviction for the woman who survived, but she couldn't identify the person who had attacked her. It was, she thought she was certain that it was Avery, but it was not. And it turns out that it was obviously somebody else, and it linked him. The DNA under her fingernails linked the crime to him. So Avery was freed only after new evidence testing conclusively said that DNA belonged to Gregory Allen. While Avery was in prison, Allen went on to commit other crimes, including violent crimes. I'm not going to say all that. So, full disclosure, Avery is once again behind bars. He was convicted of a 2005 unaliving and is currently in the Fox Lake Correctional Institute. And that is a story I definitely want to work on as well. I want to do some deep dives on that to find the truth somewhere, because it's always somewhere in the middle. All right, so defense counsel ready to take difficult cases. Oh, so this is the guy whose website I used, and if anybody needs a lawyer and is in that area, I don't know where he's from. I think it said on his website. Not that I'm trying to promote this guy. I have no idea if he's a good guy or not, or a good lawyer or not, but this is his website. I just found it. See, he's in Milwaukee. Okay, that's all I was looking for, was his address and information. If you're interested and need a defense attorney in Milwaukee, this guy knows about Denny. So that's all I know. That's the only thing I can vouch for. He had an article on his website about Denny, and that was helpful for me. So now that we have a little bit better understanding of Denny and how you have to meet the 3 prongs, and it's kind of a high burden to meet, but it's weird that Wisconsin has it and not all states do. But anyways, we're going to dive into it. So this is the court filing from the defense, and they are putting in notice of motion and motion to permit third-party Denny evidence. And this is going to speak a lot to another person, another individual. This is a court document. I'm not naming any names. I'm not saying this person did it. I'm just saying I'm just reading what's here. Okay? So let's begin. This was addressed to Michael Gravely, and it is from, you know what, oops, sorry. I bumped the mic there. I always mean to look to see who signs it. Okay, so they all did, all 3 of them, Nicole, John, and Kirk Obear. John Birdsall, Nicole Moeller, and Kirk Obear. All right, so let's go to the top. All right, so to Michael Gravely, he's the District Attorney of Kenosha County. Please take notice that the defendant, Mr. Zachariah Anderson, appearing by undersigned counsel and upon all records, files, and proceedings heretofore, had taken and taken herein, will appear in Branch 3 of the Kenosha County Circuit Court, presided over by the Honorable Bruce Schroeder. So we got the same judge and everything again. All right, so move the court to permit at trial evidence that another person, specifically Michael A. Campbell, committed the crimes of first-degree intentional homicide and hiding of a corpse, 2 counts for which the defendant is being tried, pursuant to State of Denny. Statement of facts. On May 19th, 2020, law enforcement responded to the residence of Mr. Rosalio Gutierrez at 3709 15th Street, Apartment 1B, in the city of Kenosha, Wisconsin. Upon arrival, law enforcement determined that the scene interfered with Mr. Gutierrez, inferred that Mr. Gutierrez had been severely injured. I guess you could say that due to the amount of BLOOD in there. It was a significant injury. Subsequent I wouldn't say necessarily that it would prove that he is no longer alive, though, to me. I don't know. I feel like it was enough BLOOD to make you think someone's possibly really hurt, but it doesn't necessarily, to me, mean that someone's life was ended. All right, so subsequent investigation led law enforcement to believe that Mr. Gutierrez was ended on May 17th, 2020. Following the investigation, the Kenosha County District Attorney's Office charged Mr. Anderson with first-degree intentional homicide and hiding a corpse. Although Mr. Anderson was charged with these offenses, the following evidence implicating Michael A. Campbell exists. And this we never heard at trial. So this is interesting, and this is an important document coming from the defense. All right, so number one, Mr. Campbell was friends and a working associate of Mr. Rosalio Gutierrez. According to several sources, they did contracting work together. Number two, according to individuals who know Mr. Campbell owed Mr. Gutierrez a large amount of money, so much that Mr. Campbell was in fear of losing his house in order to pay Mr. Gutierrez the money that was owed to him. I thought it was the other way around. I thought Rosalio owed Mr. Campbell money, but I guess it's the other way around. And it was so much money that, so what were they doing? Because Rosalio didn't have money. He was getting money from his mother and stepdad. They were paying for his rent and things. So what was going on that there was all this money going out with Mr. Campbell and Mr. Gutierrez? I don't know. So much money that Mr. Campbell was in fear of losing his house in order to pay him back. So that's how much it was. 3. On May 14th, 2020, now this is 4 days potentially before he went missing. On May 14th, Mr. Gutierrez withdrew $700 from his checking account. He then withdrew another $300 on May 15th. There is nothing in discovery that established Mr. Gutierrez had gone anywhere from May 15th to May 17th and spent the $1,000 he had in his possession. The contents of Mr. Gutierrez's wallet was recovered in the freezer of his apartment, but there was no U.S. currency located in his wallet, the freezer, or anywhere in his apartment. From Mr. Campbell's phone records, it is known that on May 18th, 2020, the day after Mr. Gutierrez is allegedly ended, Mr. Campbell texted his mom and asked her if she could drive him to 2 separate banks. So does that mean he made some deposits in those 2 separate banks in the amount of $1,000? I don't know. Number 4, Mr. Gutierrez's phone records indicate that he was going to see Mr. Campbell on May 17th, 2020. Further, Mr. Campbell's GPS data from a Cellbrite download indicates he was at 3709 15th Street, Mr. Gutierrez's apartment, on May 17th. So the day that the state says he goes missing, Michael Campbell's phone was at Rosalio's apartment. Number 5. Mr. Campbell had interjected himself into police investigations multiple times. First, Mr. Campbell arrived on scene on May 19th, 2020, almost at the exact time law enforcement arrived on scene. Almost at the exact time law enforcement arrived on scene. How he knew to be there or that law enforcement would be on scene is unknown, but certainly perplexing. Yes, it is. Second, Mr. Campbell and his friend Brandon Hendrickson then traveled to Mr. Anderson's residence in Mequon, Wisconsin. When he arrived at Mr. Anderson's home, Mr. Anderson called 911, given there were 2 unknown individuals snooping around his property and yelling for Mr. Anderson to come out of his house. Mr. Campbell and his friend left the residence, but law enforcement later told him that he needs to stop interfering with the investigation. So law enforcement themselves said, hey, Mr. Campbell, stop doing shit in this investigation. You're injecting yourself and you need to stop. So that was the 19th. So the 17th, he was at Rosalio's apartment, or his phone was. Usually the person's with their phone. And then on the 19th, the day that he's found, he's on the scene of the crime, at the scene of the crime, before, like, almost at the exact same time that law enforcement shows up. And then him and his friend go and try to, he was busy that day. Him and his friend then go and try to attack Zach. or intimidate Zach. Whatever it is, they were there to intimidate him. All right, so number 6, Tammy Milliger told law enforcement that she heard people talking about Mr. Gutierrez, and that these individuals mentioned that they believed the people who did construction work with Mr. Gutierrez had went to the apartment and ended him. So this person told law enforcement that she overheard people talking about this and saying that people that he did construction work were the ones to blame. Ms. Milliger furthered that they mentioned Mr. Gutierrez was rolled up in a carpet and taken to Pheasant Run landfill in Kenosha County. So I don't know if she was the tipster. She might have been the crime scout tipster, one of them that said this. I can't remember how this tip came in, but yeah. So somebody places Michael Campbell going to Pheasant Run landfill in Kenosha County. Number 7. John Hunt, an individual who knows Mr. Campbell, told law enforcement that a few days after Mr. Campbell went missing, he saw Mr. Campbell and noticed that Mr. Campbell had cut his hair and was all cleaned up. That is a big, big red flag. If somebody changes their appearance right after somebody's missing and their life is ended. All right, so according to by someone else's hand. All right, so according to Mr. Hunt, this was unlike Mr. Campbell because Mr. Campbell was always meticulous with his hair and appearance. This was unlike him because he was always meticulous? Mr. Hunt noted that the same day Mr. Campbell had items in his truck, including a rolled up carpet. Mr. Campbell said he was taking the stuff to Pheasant Run landfill. Mr. Hunt had asked Mr. Campbell for the carpet because he would use it in his back patio area. And Mr. Hunt also said that it would help Mr. Campbell because it would lighten his load, which in turn would cost less for Mr. Campbell to offload because he was going to the dump. And you have to pay for what you leave. So Mr. Hunt said that Mr. Campbell was adamant that he could not take the carpet. Mr. Hunt thought that was odd. He just wanted it for his back patio, just to get rained on and whatever. But no, Mr. Hunt said it was odd. So that is, to say he was adamant you cannot have the carpet. It's interesting. Number 8. From Mr. Campbell's Cellbrite download, there are messages where multiple people ask Mr. Campbell how he knew details about what had happened to Mr. Gutierrez. And Mr. Campbell told those individuals that he had been in contact with Sadie Beecham on May 19th, 2020, and that is how he knew about what had happened and how he got the information about Mr. Anderson. However, his phone records do not reflect any communication with Ms. Beecham. Further, Ms. Beecham's phone data show that she was never in contact with Mr. Campbell. So, someone's lying. Did he think no one was going to look and back that up? I don't know. All right, so number 9. There is evidence that someone was in Mr. Gutierrez's apartment on May 18th. From other evidence, it is evident that Mr. Anderson was not in Kenosha on May 18th, but Mr. Campbell was in Kenosha on that date. And what did I say in my last episode? I said, what if the diffuser was turned on by the person who ended him to drown the scent, to turn, to confuse people about the timeline? I mean, BLOOD itself has a smell, so sitting around, if there's enough of it in a room, you're going to smell that, and it's going to start to smell bad, and other people might notice it. So I wonder if Campbell went back, and this is just speculation, just hypothesizing if this is all true. I wonder if Campbell went back and turned on the air diffuser, the essential oil diffuser. It's not hard. You just fill it with water and an oil, that you want, and then you turn it on, leave it running. Mine only goes for, I think, like 2 hours. It turns itself off. But that one, like I said, had, like, I think, an 18-hour, which it lasted about 18 hours or so. So it shouldn't have gone from Sunday night to Tuesday morning that whole time. So that's interesting. That aligns with, he might have returned to the apartment. Anyway, so 9, there is evidence that someone was in Mr. Gutierrez's apartment. Okay, so I just said that. Sorry. Number 10. Although the quality is not the best, surveillance video obtained by law enforcement depicts several trucks driving on 15th Street between 8 p.m. on May 17th to 2 a.m. on May 18th that match the type and color of Mr. Campbell's truck. So not only do we not have Zach's car on film any time around Kenosha, but we have several trucks that drive by that we could possibly identify as Mr. Campbell's truck. 11. To date, Mr. Campbell has not provided any information to law enforcement that would preclude his involvement. Legal authority. The right to present a defense is grounded in the Constitution and compulsory process clauses of the Sixth Amendment to the U.S. Constitution and Article 1, Section 7 of the Wisconsin Constitution, Chambers versus Mississippi, State versus Polizano, yada yada. All right. A defendant's right to present a defense may, in some cases, require the admission of testimony that would otherwise be excluded under applicable evidentiary rules. See also State versus Jackson. So, normally the rule is that evidence of motive of an individual other than the defendant to commit the crime is inadmissible. State versus Denny. However, if there is no evidence that said individual has a direct connection, motive, and opportunity to commit the charged offense, then third-party evidence should not be excluded. Let me read that again. If there is evidence that said individual has a direct connection, motive, and opportunity to commit the charged offense, then the third-party evidence should not be excluded. It should be allowed, basically. So anything that ties all three, we meet all three prongs. He had a direct connection. He was best friends with Rosalio. I don't know why I'm trouble saying that word all of a sudden. All right, okay. So we knew he was friends with Rosalio, best friends. We know he had motive because he owed Rosalio a ton of money. And the opportunity was there because he was in Kenosha both times. And opportunity, there was $1,000 cash that we don't know where it was or if it was ever even found. I don't believe it was ever found. Not in Rosalio's apartment. So, that being said, that could have been another motive / opportunity. It's right there in front of me, this cash. I can end him, I can take that cash, and then all my problems of owing him the money go away, and I get $1,000 in return. I don't know, I'm just speculating. It might not have gone like that, but we do have direct connection, motive, and opportunity, so it should be included. In determining whether to allow third-party evidence, the Wisconsin Court of Appeals refused to adopt the standard established in Pope versus Green and rather adopted the less stringent legitimate tendency test established by the U.S. State's Supreme Court in Alexander versus United States. The Supreme Court of Appeals holds that a defendant shows legitimate tendency when motive and opportunity have been shown, and as long as there is also some evidence to directly connect a third person to the crime charged, which is not remote in time, place, or circumstances. Therefore, if a defendant can show that a third party not only had the motive and opportunity to commit the crime, but was also placed in such proximity to the crime as to show he may have been the guilty party, the evidence would be admissible. So you need to allow it. Here, there is evidence that Mr. Campbell had the motive and opportunity to commit the crime, and he was also placed in proximity of the crime to show he might have been the guilty party. When looking to opportunity, the question that this court must determine is whether the alleged third-party perpetrator could have committed the crime in question. Doesn't mean necessarily that he did, just that he could. So it is the defense's position that Mr. Campbell could have committed the crime in question. From the information available to the defense, Mr. Campbell was at Mr. Gutierrez's apartment on May 17th, and from May 17th to May 19th was in or directly around Kenosha. Interesting. So there are witnesses who observed Mr. Campbell around May 19th, 2020, and observed him acting strangely and having changed his appearance in that he was clean-shaven, which was not like him. So it was not like him to do it. There was a typo up there. They left out the not. Not like him to be clean-shaven and have, clean-cut hair. So there were statements from other witnesses that Mr. Gutierrez's body was dumped in a rolled-up carpet at Pheasant Run landfill, and according to Mr. Hunt, Mr. Campbell told him he was taking a rolled carpet to Pheasant Run landfill around May 19th, 2020. It should also be noted that although individuals saw Mr. Campbell with his truck around May 17th to May 19th, Mr. Campbell was asking other people to drive him around. That's weird. The fact that his truck was working, but was asking other people to drive him to public places is a fact that should not be ignored when completing an analysis here. Although proximity cannot be established by mere presence, circuit courts must access the proffered evidence in conjunction with all other evidence. Looking at the fact that Mr. Campbell was at Mr. Gutierrez's apartment in conjunction with the facts that Mr. Campbell, 1, owed Mr. Gutierrez a substantial amount of money, 2, continuously intervened with law enforcement's investigation, and 3, provided inconsistent answers about how he obtained information relating to Mr. Anderson and Mr. Gutierrez, 4, had been observed by people to have changed his appearance immediately after Mr. Gutierrez's disappearance, and 5, had a rolled-up carpet and other items that he took to Pheasant Run landfill. There is evidence that Mr. Campbell had motive to commit the charged offenses of the first-degree homicide and hiding a corpse. Conclusion: for the reasons within this motion and for any reason stated on the record at a hearing on this motion, the defendant respectfully requests that this court grant this motion and allow the defense to present third-party evidence against Mr. Campbell. And signed Nicole Muller, John Bertzel, and Kirk O'Bear. So that was their motion to present information for Michael Campbell. What do you think? I think that's pretty strong. They have several reasons why he should have been introduced as a Denny third-party guilt opponent, whatever you call it. I don't know. So let's see what the state had to say in response to that. We do know that this gets denied, so I'm not all excited about listening to the state ramble on for however long, 9 pages. So unfortunately, you have to hear me ramble on. So the state agrees that the appropriate legal analysis for the court to consider is State versus Denny, as well as its discussion of Alexander versus Wisconsin. Denny indicates, in quoting Will Alexander, "We believe that to show legitimate tendency to a defendant should not be required to establish the guilt of third persons with that degree of certainty requisite to sustain a conviction in order for this type of evidence to be admitted." So it doesn't have to be you don't have to establish guilt to for the third party to a degree of certainty to add a Denny party into your evidence. On the other hand, evidence that simply affords a possible grounds of suspicion of another person should not be admissible. The Denny court indicates where it is shown that the third party not only had the motive and opportunity to commit the crime, but also was placed in close or in such proximity to the crime as to show that he may have been the guilty party. The evidence would be admissible. Interestingly, the Denny court indicated that their suspicions were insufficient, with multiple witnesses willing to testify that the victim may have gotten in trouble with a big substance dealer. The same proposed witness would have testified that the victim owed this individual a sum of $130. A second proposed witness would have testified that the victim may have had an enemy. This is all according to this particular Denny motion, or the defendant for Denny. Second proposed that he had testified against the victim may have had many enemies, and in an individual who traded a shotgun to that victim for a controlled substance where they may have had a dispute about the circumstances. So the Denny court found that motive had been established in these cases, but that there was no evidence of opportunity or direct connection to the crime. Based on the failings identified above and the requirements of case law, the state believes that the defense cannot present a factual basis for a Denny defense to be raised. The state will now go through the 11 factual assertions of the defense motion, pages 2 and 3, and indicate the counter-arguments that indicate that the defense arguments fail in any Denny analysis. State's response to paragraph 1 of the defense submission. The state agrees that Mr. Campbell was a close friend and working associate of Rosalio. They did contracting work together on a periodic basis. None of this indicates a motive or a reason for homicide. No, that's your connection. Of course, that's your connection to the victim. That's what it establishes. State's response to paragraph 2 of the defense submission. The defense is asserting that one individual, John Hunt, had knowledge that Mr. Campbell owed Mr. Gutierrez a large amount of money. They then apply that Mr. Campbell was in fear of losing his house to pay that money, and so imply that there is a motive based on the debt. Mr. Campbell himself, as well as his girlfriend, at the time, Erica Saylor, indicate no significant amount of money was owed by Mr. Campbell to the victim in this case. In fact, Mr. Campbell's cell phone download actually shows a message from the victim on May 15th, 2020 at 6:30. This would be just over 2 days from when we believe the victim was ended. In his 2 days before, May 15th. Okay, so in this phone message from the victim to Michael Campbell, the victim asks Michael Campbell if he wants the victim to come over and pay him before he goes and gets his son, who visits him for the weekend. So in fact, rather than Michael Campbell owing the victim money, it appears that the victim was attempting to pay Michael Campbell money. Not necessarily. It could have been him borrowing money because he was in need of it. And maybe Rosalio is being a good friend and going, okay, you can have this $700. I'll just ask my mom to cover me again for another month because you begged me for it, and here it is. I don't know. You don't know that. You don't know the circumstances as to why Rosalio was giving Michael Campbell money. You're assuming that he was paying him a debt, but it could be the other way around. So, in fact, rather than Michael Campbell owing the victim money, it appears that the victim was attempting to pay Michael Campbell money just 2 days before the unaliving. This is the opposite situation than the motive described by the defense. So, even if Michael Campbell, even if Rosalio was if it's in reverse and Rosalio owes Michael Campbell a bunch of money, well, then that would be also motive. So you're not really taking motive away by saying, no, it's the other way around. You still could have motive. It's just opposite. I don't know. These people, the way prosecutors spin things sometimes, it just really irks me. All right, so the state is unaware of any other conversations between these parties about money being owed by Michael Campbell to the victim. In fact, everything the state knows about this case is that the victim was operating with very limited means. His mother was assisting him in paying the rent. That's what I'm saying. Maybe she was helping him because Rosalio was paying his friend Michael Campbell out of his, his kindness to help him out of some sticky situations or something. I don't know. Anyways, his mother was assisting him in paying the rent. She was also buying him items to furnish his apartment. He was clearly not in financial circumstances where loans would have been available to give to close friends. We don't know. He might have been doing it. Maybe Michael Campbell pressured him to the point where he blackmailed him or something. Who knows? Mr. Hunt claims that he hears the information about loans from Michael Campbell's sister, who he transports to methadone appointments. Michael Campbell's sister is deceased, and Michael Campbell says that she was an individual who constantly told tall tales or made up stories regarding all the circumstances of her life and everyone she knew. Again, Michael Campbell and Ms. Saylor indicate that himself and the victim occasionally owed each other money from the contracting business, and that it was never more than $1,000, and that, in fact, he and Ms. Saylor had socialized with the victim on the same weekend that he went missing on that Sunday. Okay, well, that doesn't necessarily mean that Michael Campbell didn't do it because they hung out that Sunday, and Ms. Saylor might not be hearing the full story of what's happening because Michael Campbell's only telling her, oh yeah, I only owe him like $100, but really I owe him 1,000 and 1,000 again and 1,000 again, and it just keeps adding up or something. I don't know. I mean, you could spin it either way, and that's why I love how that's why I like this stuff, because you can look at things from both sides, and it's really interesting, like how you can take an argument and here's the counter argument to it. It's just very interesting to me, but I don't necessarily agree with all the counter arguments or whatever, but I think it's interesting to see how you can spin it to your own perspective to make it fit your narrative. Anyway, so the state's response to paragraph 3 of the defense submission. Defense paragraph 3 indicates that the victim made 2 withdrawals on May 15th and then had no money in his wallet because when his wallet was recovered in the freezer of his apartment, no currency was located. This presupposes that the defendant, Zachariah Anderson, did not take any cash when he manipulated and moved the wallet into the victim's freezer. At the same time, he placed the victim's phone in the freezer. Prove that Zachariah did that because you didn't test it. You didn't have his DNA anywhere. Zachariah's DNA was not found anywhere in the apartment or on Rosalio's things. All right, so additionally, by far the most logical reason for the cash to have been taken out was the context of the text explained in paragraph 2. If he owed Mr. Campbell money, he likely took that money cut to be able to give it to Mr. Campbell. In addition, the family members of the victim indicate that he paid for baseball equipment for his son, Julian, as well as paying for private coaching for Julian during that time period, and those transactions were likely in cash. So the state's response to paragraph 4 of the defense submission. The defense alleges that the victim's phone records indicate that he was going to see Mr. Campbell on the 17th. This is based on the victim texting Sadie Beecham, the ex of Zachariah, who had a 3-month relationship with the victim, that he would be headed to Mike's house when he was communicating with her on the 17th. A logical assumption is that the victim intended to take the money he had withdrawn and was planning to stop by Michael's house to pay him that money. Maybe, maybe not. Like I said, there's other reasons why he could have been paying him the money, not because he owed him the money, but because Michael needed the money. So it is possible that he communicated that he was going to Michael's house because he wished to deceive Sadie Beecham after he had already made arrangements for a different woman, Narita Macias, to come to his home that evening. Maybe, but he might have said, hey, I'm going to stop at Michael Campbell's first or something before I stop home, because he was running a bunch of errands, dropping his kids off and running places, or I don't know. Maybe I'm just thinking he was running places because of all the lies he told. So he was he was out and about dropping the kids off. I know that. And the kids, he has 2 children from 2 different mothers, so he was driving around dropping the children off from that weekend. All right. So paragraph 4 of the defense submission also indicates that Mr. Campbell's GPS data from the Cellbrite indicates that he was in the location of Mr. Gutierrez's apartment on May 17th. Mr. Campbell and Erica Saylor were social visitors to the victim's apartment on that weekend. The time that the defense is describing is at 1:46 a.m. on the 17th. This is 19 hours prior to Mr. Gutierrez's unaliving, both on all other evidence available. During those 19 hours, both of the victim's children's mothers, and electronic evidence shows that the victim was very much alive and still in regular contact with all those that he cared for. It is possible that Mr. Campbell dropped by to pick up the money. That was the previous text conversation. In any case, his presence at the victim's home 19 hours before any allegation of homicide is absolutely no evidence of proximity in this case. I don't know about that. Especially if you're saying he's a social visitor. So, okay, he has the opportunity and means to, do it often. If he's there all the time, like, usually it's somebody close to you who is going to be the one to end you. It's usually someone you know. And he didn't know Zachariah. Zachariah might have had some jealousy issues or struggling with his feelings over the relationship ending with Sadie, but that doesn't necessarily make you a life ender. Usually it's someone you know. Anyways, so the state's response, let's move on, or did I finish that camp? In any case, his presence at the victim's home before the allegation is absolutely no evidence to proximity. In this case, the choice by the defense to not provide the factual information that the only GPS data from Mr. Campbell's phone alleging that he was at Mr. Campbell's apartment is 19 hours earlier. I don't know about that because they said he was there the 18th too, so I don't know. And he might not have taken his phone in to do said crime. You know what I'm saying? Like, he might have been in the area in Kenosha that day, and then he didn't take his phone when he returned back to Rosalio's house if he went to go attack him. Because it was definitely a surprise attack. It was Rosalio, somebody knocked, Rosalio opened the door for somebody, and then he got probably hit, bludgeoned, I don't know, by some object because of the spatter that we see on the door, the frame, the inside of the back wall when you walk into his apartment. Anyway, so response to paragraph 5 of the defense submission. The defense alleges that Mr. Campbell had interjected himself into the police investigation in this case and describes those circumstances as somehow suspicious. In fact, police reports indicate that Michael Campbell first arrived at the victim's residence on May 19th at 2 p.m., approximately 2.5 hours after officers first arrived on scene. Mr. Campbell indicates when asked directly this question that he had received a text from Eileen Knoll earlier indicating that she had not been able to reach the victim. So now it's Eileen Knoll, it's not Sadie, although he said it was Sadie originally. Mr. Campbell indicated that he assured her that he would go to the house and check on him. That is how Mr. Campbell ends up in the victim's home on the 19th. Additionally, Mr. Campbell indicates that the victim had previously told him that Sadie's ex-boyfriend was tracking him and was crazy. Erica Saylor I think that just works in your favor, doesn't it? To pin it on somebody else. Erica Saylor indicates that she was living with Michael Campbell at the time, and when Michael Campbell returned home and talked about having stopped at the victim's apartment, that Erica Saylor herself started looking on Facebook because she was aware that the victim was having problems with Sadie's ex-boyfriend. Erica Saylor is the one who found out who the guy was, and checked CCAP. So the CCAP, I don't know what that is, but it's some database for Wisconsin people where you can look people up. And she was the one who provided the address through Facebook and CCAP, as well as the name of Zachariah. All right, so Brendan Henderson indicates that he was contacted by Michael Campbell on May 19th, and he went over to Michael's house, and Michael was talking what he saw when he went over to look at the victim at his house. Brandon said that Erica Saylor looked on Sadie Beecham's Facebook and found out the ex-boyfriend's name, and that she then found the guy's address, which was north of Milwaukee. Brandon stated that he and Michael immediately got into the car and drove to see the guy without even knowing what he looked like. Interesting. And that's coming from the state. The state is alleging that they just took off and left without even knowing what the guy looked like. That's how angry they were, and how it was going to be an angry confrontation, rather than they tried to make it seem like, oh, I was just going to go over there and ask him questions. That's all. Baloney. Okay, anyways. State's response to paragraph 6 of the defense submission. The defense indicates that Tammy Milliger, I don't know, Milliger sounds right to me, indicated that she had heard people talking. So remember, this is the tip. She heard people talking about the victim and indicating that they believe that people who did construction work with Mr. Gutierrez had gone to his apartment and ended him. Per the defense, Ms. Milliger is again quoting John Hunt and his speculation in this case. In fact, John Hunt's only source was Michael Campbell's sister, Tony. That's not true, because John Hunt was talking to Michael Campbell about, and saw it with his own eyes. He saw the rug. Anyways, so he's the only source. His only source was Michael Campbell's sister, Tony. So the detective Correa's report, where John Hunt summarizes the submission with Tony, John Hunt is quoted as saying that Tony told him that Michael Campbell was at the police department because he was the victim's business partner. In fact, Detective Carrera says that Michael Campbell was at the state police department because he had gone to the household of Zachariah Anderson. Tony is demonstrably wrong in one of the facts that she supposedly asserts to John Hunt. John Hunt quotes Tony as actually telling John Hunt that Michael Campbell was at Guy's house who made his partner disappear. Therefore, John Hunt was being told by Tony that when Michael Campbell went to Zachariah Anderson's home, that was the person who ended Rosalio Gutierrez. I don't know. I don't know if I believe that those quotes were being told by someone else to John Hunt, but let's see what else they say. I really don't believe much that the state says, but, I mean, I'm trying, but I think they got the wrong guy in this. All right, so the state's response to paragraph 7 of the defense submission, the state agrees that John Hunt noticed a change in the haircut of Michael Campbell in this case. However, John Hunt's reference to Tony stating that Michael Campbell's haircut had happened 4 or 5 days before this means that the change in haircut and appearance would have predated the homicide. Okay. When John Hunt described the incident with the rug, the police officers were quite focused on that item. An area rug is missing from Rosalio Gutierrez's apartment in an area that clearly indicates that there was red fluid DNA on it before its removal. This is a dark gray striped area rug per reports from the family. Okay, Mr. Hunt instead described a wall-to-wall carpet and described it as tan. The carpet described by Mr. Hunt is in no way consistent with the rug that's missing from the victim's home. We don't know that because we don't have evidence or pictures or no evidence collected or anything of that nature. So we can't even look at a picture of it. This is clearly outlined in the written statement provided to law enforcement by John Hunt. All right, whatever. So, state's response to paragraph 8 of the defense submission, both Michael Campbell and Sadie Beecham confirm that Michael Campbell was in touch with Sadie Beecham on May 19th, 2020, after he had already proceeded over to Zachariah Anderson's house. This is not reflected in the phone records because it is a communication on Facebook Messenger. Any representations Mr. Campbell made that he had spoken to Ms. Beecham are absolutely accurate. Consequently, they are not a reason for any suspicion. Okay, if you say so. I think the Denny motion is pretty strong, in my opinion, but as we know, it got denied, and I'm not a judge. So, state's response to paragraph 9, I wish I was. It would be such a fun job. But maybe not. Because some attorneys act like children when they are arguing with one another. All right, so state's response to paragraph 9 of the defense submission. The defense indicates that there is evidence that someone was in Mr. Gutierrez's apartment in May 18th, as well as an absence of any evidence that Mr. Anderson, the charged defendant, was in Kenosha on that date. Mr. Campbell resides in Kenosha and was certainly in town by anyone's expectation. The state contends that there is no known reason that anyone was in Mr. Gutierrez's apartment on the 18th. How about the diffuser? Perhaps the defense is referring vaguely to the diffuser, which has now been tested by law enforcement. Sergeant Bandy reported a test he conducted in July 2022 that when the specific diffuser previously in Mr. Gutierrez's apartment is filled with water, that it continues to give vapor for 46 to 50 minutes and 43 seconds. Oh, so 46 hours? No, there's no way that runs for 46 hours. Okay. I run through all my water in, I fill it up and it goes maybe 4 hours before it's all gone. I don't know how much water goes in there, but I mean, even the water itself is going to evaporate and it's going to turn off eventually. It's not going to all just stay on for 46 hours. That's ridiculous. All right, but that's their test, they said. But the defense, I don't think, ever got a chance to test it, or if they did, I don't know what the results were. I hope they got it now. Like, now that we're in appeals and trying to... So, it obviously, the diffuser mattered because they got it now. Because they said in previous motions that it was in the possession of the mother in another state. She took it when they cleaned out Rosalio's apartment. She took it back to her place. I think she's in Colorado, I want to say. I can't remember for sure. So they obviously got it. They did some testing. They say 40 hours. All right, so assuming Mr. Gutierrez, knowing that he was having a visit by Ms. Macias, who would be seeing him for the first time in his apartment on May 17th, filled the diffuser at 9 p.m., maybe he did, but maybe the ender also came back and filled it back up, put essential oils in it. I don't know. When he first arrived home, then the diffuser, if this is Gutierrez, assuming he filled the diffuser at 9 p.m. when he first arrived home, then the diffuser would certainly still be running throughout the day of May 18th. And in fact, when officers were taking pictures and surveying the scene, you could see that it was still steaming. Would still have been within 40 hours of the diffuser being filled with 6 or 7 hours to go. The diffuser provides absolutely no evidence that anyone was in the apartment on May 18th. The defense alleges that during a time period from May 17th through May 18th, several trucks go by that look to be a type and color consistent with Michael Campbell's truck. The same is true of the van operated and owned by Zachariah. Okay, but you never caught Zach's van. That's the point. And you didn't look for Michael Campbell's van because you were focused on Zach's van. That's the problem. So, state's response to paragraph 11 of the defense submission: Michael Campbell has not provided any information strictly to law enforcement that would preclude his involvement. Erica Saylor has indicated to the Kenosha District Attorney's Office, as has Michael Campbell, that they were home with their children on the evening of the 17th. And his phone takes pictures that evening of some sushi that they had and of one of the kids. So that's what we have as his alibi, his strong alibi. He was home with the kids. I enclosed pictures of Ms. Saylor that Ms. Saylor provided to the Kenosha District Attorney's Office, indicating the food ordered by the family for their meal that evening, as well as a picture of the family watching movies, where the items of clothing in the picture are, per Erica Saylor, being worn by Michael Campbell on that evening. Consequently, Michael Campbell has a firm alibi confirmed by a witness and by photos for the evening of the 17th, when Mr. Gutierrez goes missing. So in conclusion, the defense has really provided no motive for this case. I think they did, but maybe they didn't go deep enough into why and how much, and maybe they needed to prove a little bit more why Michael Campbell was struggling with his finances. All right, so the defense has really provided no motive in this case. All the tangible evidence that we have is that Mr. Gutierrez is the one who owed Mr. Campbell money at this time, rather than the reverse alleged by the defense. We don't know that. So that's why I was confused, I guess, because the state is saying that Rosalio owed him money, but the defense is saying that Rosalio owed Campbell money. So I am confused thoroughly by it all. And so the gentlemen were close friends. They socialized within 48 hours of the homicide. That doesn't mean that he didn't do it. Something could have occurred in that 48 hours that made Michael Campbell more upset or put more pressure on him to pay Rosalio back or something. I don't know. So Mr. Campbell is the type of friend who would drive to a location of possible danger to try to figure out what has happened to you and to see if you could be saved. No electronics place him in that location of Mr. Gonzalez's apartment when he has gone missing. Why is his character coming into this? I don't know. No electronics place him there. This is in contrast to the state crime lab asserting that BLOOD of Rosalio Gutierrez is found in Zachariah's van. That is a misstatement of fact. That is not true. They never concluded that. A woman testified that it was consistent with Zachariah's DNA, but Rosalio's DNA, sorry, but they never proved it. And even her own notes didn't say that. Like the lab tech person that was doing the investigation with her said it wasn't Rosalio, and they didn't find any DNA, period, in the car whatsoever. They did luminol testing. There's a tiny little speck of something that lit up, and it was too tiny to really do anything, and there was nothing of evidentiary value. I think they did a swab on multiple tests. They did swab multiple tests, and all of them came back negative throughout the van. So, did they test Michael Campbell's van or truck? I don't know. No electronics place him in the location. That's in contrast. Okay. Zachariah Anderson's phone is turned off during the relevant period, and he and his girlfriend at the time both attempt to fabricate a false alibi for him during the time. So they're saying that the girlfriend lied when she was like, I don't know, he was probably home or probably here with me. That's, not necessarily a lie if you don't remember thinking like, oh, I think he was here. But ask my sister, she might remember better, I think she said. All right, so there is documented evidence of a strong motive, as he was jealous of the new relationship that his ex, Sadie Beecham, was having with the victim. Shortly, there is documented evidence of his stalking Rosalio Gutierrez. I don't think so on that one, some of which has been admitted by the defendant to law enforcement. Consequently, the absence of any real motive or supporting evidence leads the court to one logical conclusion that the Denny motion should fail. So they're saying deny it. The Denny motion should be denied. You should give them a big old fail. And that, this was signed Jessica Kasarek. So Gravely didn't even do this. I wonder why Gravely's not on here. So yeah, that was the state's response to the Denny motion. We know it was denied. We know that the evidence about Michael Campbell did not come in. However, I absolutely feel that if it was allowed to come in, there would be enough reasonable doubt for Zach. And he would have gotten a fair trial. I don't understand why you can't bring up another person, but I mean, that's the law and that's the way it is. But I still don't understand why her motion failed. I don't think that the state really provided excellent points in their arguments. I think that they could be easily refuted. All right, so that's it for this episode. Next episode, I think we might start doing some analysis of the trial. So bear with me on that because I'm not exactly sure how that's going to go. But I think we've gone through everything up. We went through the incident, the beginning of everything, up until now. We're at the Denny motion, and we're going to go to trial again in March. So this was, I believe this was, is there a date on here? This was filed 2/9/2023, the Denny motion was. And the response to Denny was 2/17/2023, and court starts in March. So yeah, this was right up until that court date where they were arguing to bring in information for Michael Campbell, and they were denied. I definitely think that there was some strong information here that point guilt to another person. Not necessarily that it means that he did it, but there's enough reasonable doubt that on Zach's end then that you're like, oh, maybe this other person did it. So I feel like it should have been let in. I know it wasn't, so that's unfortunate. What do you guys think? Let me know in the comments below. Don't forget to like, comment, subscribe, and if you have any suggestions or comments about this particular case or others you want me to cover, any wrongfully convicted people that you want me to read, to look into, to find information out, I would love to take suggestions. So I'm open to hearing from you. Let me know in the comments below, and I will see you next time. Thanks so much for watching. Take care.